We've brought together 50 bankruptcy lawyers, one from every state.
Does it matter how I structure a new business in a Chapter 13?
On today's show, bankruptcy lawyer Matthew Frey from Michigan goes beyond just a quick answer.
Does it matter how I structure this business? And the answer from the bankruptcy perspective is predominantly going to be no. One thing that we remind people during their intake calls frequently is the business is not you, if you have an LLC or an S Corp or a corporation. But if you own the shares, if you're the sole member, you are the business. You own it. Therefore, it's an asset of yours. So if you propose during your case, I'll file for an LLC, nobody can stop you. Okay, it's just a form you file with your state. It says I want to open an LLC, and in Michigan here, costs just a few bucks. You can have an LLC. If you're going to borrow money, though, remember, no legitimate lender is going to give your business money without a personal guarantee. I know there's ads on YouTube. I see them on Facebook where, you can use this LLC trick, if you will, to do all these different things. That's not real. Okay. That's either a scam towards the lending company or a scam towards you. My rule of thumb when taking advice from any of those individuals online that are selling a course or selling a system and not just a product is if they were so successful at their product, why are they trying to teach you how to do it? It's usually because they're not. No one's going to step away from a large business to basically invest in multiple random people they don't know for whatever dollar for their course. They're going to be doing the bigger deals. Okay. So the question, does it matter if I try to insulate myself? The answer is going to be no, because you're going to own the business. Those shares of stock, the ownership interest may vest in your bankruptcy estate. You need to read your plan. Your plan should tell you that much. Or your attorney can tell you if you don't read the plan thoroughly on your own. And then number two, you're going to personally guarantee all that stuff. The bank, the credit union, the lending institution, they're going to want the personal signature. And you're right back where you started with, I have to have court permission. Now, as a small follow-up to that, what happens if you don't get the court permission? They do give you the money, okay? This happens. As you can see, at one point in time, I probably had a full head of hair, and these kinds of situations reduced that to where I am now. And because you want to pull your hair out as an attorney when clients tell you, I went and did this, and it's like, well, wait a minute, you were supposed to get court permission, and I want to tear my hair out, but I don't have any left. Your case can be dismissed for fraud because you violated your plan willingly, and you can get a bar on refiling. There are some very aggressive trustees in the system that will look at what you've done and will say this person has done something that they shouldn't have. They flagrantly flouted the rules, if you will, and we should have a bar on a refiling. And that can be horribly detrimental. People lose stuff all the time for these things. And a lot of times we see this with pro se debtors, where a pro se debtor doesn't know what they're doing, doesn't know what to file, especially in a Chapter 13 case. And they'll get multiple dismissals. And the court will step in, or the trustee will step in and basically prevent them from refiling. And then that's going to give your creditors a period of time where they basically get in free hits. They've got all your information now, at least to the extent that you provided it to the court, in case you're missing documents, but they get free hits. You get a 6-month bar, a 1-year bar, a 2-year bar. You don't have anywhere to turn for help. So again, you really have to think this stuff through. And as I tell people, if it's a business that's going to cost you money, really consider what is the alternative. Is it a timing issue? Is there something going on? Many of us have a side hobby or side interest and things like that. If you want to be a t-shirt printer and buy a $200 heat press and go on Etsy, no one's going to care. If you want to buy a $20,000 screen printing machine and you have no customers, and you're hopeful that your ad in the local high school paper will get you team t-shirts, that's not going to work. You really need to spend some time thinking about these things, just like if you weren't in bankruptcy. You really got to spend time considering the business, considering the structure, how you're going to make money, unless you've just got money to throw away. But again, if you're in bankruptcy, you're not going to have that because the court's going to require you to pay that to them.
There is so much bad advice out there, and you don't want to stay stuck. We have the top experts to pull back the curtain on how the system really works. Hit that subscribe button so you're always armed with the truth.